Okay, I think in the interest of staying close to schedule, we're going to go ahead and get going. My name is Heather Whiteman-Rensham, and I'm a senior staff attorney at the Native American Rights Fund. I am a proud citizen of the Crow Nation of Montana, also a descendant of the Lakota tribes, and I'm really pleased that I was asked to fill in at the last minute on this panel because it's one that I think is particularly timely and interesting and very, very important for the purposes of this conference and the ongoing work that we're all doing. I'm joined here by four very distinguished panelists. First, we will have a presentation by Judge Greg Bigler. He's Yuchi, and he works as a judge for the Muskogee Creek Nation. He's also a sole practitioner in Indian law, a judge on several tribal courts, and currently sits on the District Court for the Muskogee Creek Nation, Iowa Tribe of the Oklahoma Supreme Court, and Kansas Kickapoo Supreme Court. He's a Court of Appeals judge for Meshintucket Pequot and a district court judge for the Seminole Nation of Oklahoma, and has served as a judge and tribal prosecutor for other tribal nations. He received his bachelor's degree from the University of Wisconsin Stevens Point and his JD from Harvard Law School. He also has an LLM from Wisconsin Law School. He began his career at the Legal Services of Oklahoma, then worked at Oklahoma Indian Legal Services and for the Muskogee Creek Nation. He established the law firm of Rice and Bigler, which, among other things, argued and won the Supreme Court case of Oklahoma Tax Commission versus Sac and Fox Nation. Judge Bigler has been heavily involved in promoting the continuation of Indigenous languages. He is the founder and past chair of the Oklahoma Native Language Association and the former co-chair of the annual Oklahoma Native Language Use Conference. Native Language Association organizes workshops and distributes materials and tools for language learning. Judge Bigler speaks Yuchi and has also studied Mandarin Chinese. And he's going to talk with us today about some of the very unique initiatives that Muskogee Creek has undertaken as far as internalizing the UN Declaration on the Rights of Indigenous Peoples, utilizing their own languages and worldview. So if Judge Bigler wants to come on up and go ahead.
Sign like the Asata. They always say it's good to have something that is a touch and feel to retain your learning process. So we will do what we can here. Sign like Asata. Nechiketale ha. Sanley. I really worked on what I wanted to say here because I believe this is such an important issue. It's something I've really believed with, and my partner Bill Rice and I had talked about these things many times for a lot of years until he passed away, about how we go about promoting something which would get us out of the trap of federal Indian law. And he had worked on this declaration and teaching students in Geneva and at Tulsa Law School many years. But first, before I go too far, how many of you here are law students? Do we have any law students in here? A couple? How about just lawyers working with tribes or in whatever capacity? A few? A couple? Okay, good. And then are there some advocates also, just whatever it might happen to be within any country? Good. When I went into this talk, I was trying to think of how I would address what I needed to do. And as Heather and a couple others here know, about 3 years ago, when Bill was still alive and right before he passed away then, and with Walter, it really was keyed because of my friend Bill's passing, that we used to talk a lot about these issues. He'd be going home from law school and he'd stop over and we'd just start drinking coffee and he'd say, I want to ask you something. As soon as he said he wanted to ask me something, it meant to me that he thought about this a lot. And he'd worked through all the ramifications and possibilities. And so I wasn't going to spring much of anything new on him, but he just wanted to see what I happened to think about. But since his passing, and I just work in tribal courts. I live in Sapulpa, Oklahoma. I work in Okmulgee. I travel to Seminole, Wewoka, to the Kickapoos, and it's even though it's Oklahoma, it's a very rural area, very Indian. So I don't get out as much as I used to, and maybe the people who are fortunate enough to work at NARF and at the law schools have a chance to visit with others. But I didn't have that chance, so I wanted to create a conversation where we think about what it is and where we want to be, because that's what we used to talk about. What do you want to have in 40 years? Where do you want to be in 30 years? So you take off all the blinders. What do you want? And I haven't had those discussions of recent, so we started some phone calls, and surprisingly enough, a lot of my friends were calling in on these. And I really appreciated that. I was very, very happy with that. Now, part of that led to an article that I put out there, which will be forthcoming in the next few days at the American Indian Law Review, but that will learn many of the things that we're going to talk about today, I think, will be in that and that we have talked about. But these conversations here, I see, are amongst ourselves internally as Indians and Natives and advocates. It's not so much for the outside world, but rather we have to decide for ourselves, what are we going to do, what do we want to be? I spoke with a friend of mine, and that's the article will be there, just a little self-promotion. And we've always had leaders within our traditional community. Now this is Cheeto Harjo, many of you don't know who he is, but he was what they called the crazy snake. And in 1906, 1900, he led the resistance to the allotment in Oklahoma within the Muskogee Creek Nation. He has a speech which you can find online, the Plea of Crazy Snake, and some magnificent dialogue from an American Indian, several pages long. I have always been asking for justice. I've never asked for anything else but justice. I've never had justice. First it was this, and then it was something else that was taken away from me and my people. So we couldn't stay there anymore. What was to be done was all set out yonder in the light, and all men knew what the law and the agreement was. That's from 1906. He's talking about the treaties, the allotment, about those agreements that removed us from Georgia, Alabama. Now, he's known as the Cheeto Harjo that led this crazy snake, but he actually was the Tustanugee at Hickory Grounds, which is the second chief and often is the speaker for the grounds in the Muskogee ceremonial grounds. So he had grown up with this role of enunciating and speaking what the chief would ask him to say on their old traditional methods. So this was nothing new to him to have a fluency. This is a picture of our former chief, Sonny Brown, Lewis Brown, who took over his spot after Sonny's passing, and Boston Rowe, who was our speaker at our grounds for some period of time, Uchis. And I'm also very lucky to have Yoni Spencer, who'll speak here tomorrow, one of our chiefs at our traditional ceremonial grounds at Polecat, and he'll talk tomorrow about some of those things. But why is a tribal court judge interested in the drip? Because we are always at the tip of the spear on attacks upon jurisdiction and tribes. If you read a federal case, it's going to be an appeal from a tribal court decision, or we're saying that the tribal courts cannot hear the matter. It's always fear-mongering. You read the Dollar General versus Choctaw, the Murphy versus Carpenter, Ryan versus Zinke, Bracken versus Zinke now. That's where we are, is the tribal courts. We're talking about inherent rights, inherent right to our institutions, because the tribal court is one of the tribal institutions. And what they use is the plenary power over Congress to attack anything that we happen to have. Ultimately, the plenary power can be used to undo anything we have. Maybe they'll have to take it if we have a trust lands, maybe, assuming it's not in a like in the Alaska situation, but they can still do it. They terminated the Menominee, Pyramid Lake. 123 other tribes have never been restored. And if you fundamentally have no right to exist, where are your foundation for any other rights? So it was explained to us when I started the translation process with our Mikos. I was very careful. I would gone, and I'm very involved in my ceremonial ways. It's 40 years now of doing that, where that is from first Easter on, we have our 4 ball games, we have everything else we do, and the inherent right to exist is in Article 3, but we consider probably in Article 5 as the indigenous institutions. Article 31, though, is what we as ceremonial people look at and fairly long about our right to our traditional knowledge, traditional ways, methodology. But in translating the Declaration, they went to what that is understood by our traditional people and how you translate the Declaration. I don't know if I can play that or not, but what they understood it, and they said this is the core of what it means to be understood. When they take that whole article, they said that for them the core point of this declaration is that these are our ways and they are very sacred. They're not to be played with. This is what was given to us. It's not to be taken outside. It's not to be done by others. It's not something to be misunderstood, put on display, abused, or taken. Even within ourselves, there's certain things that we have to do. And that's what we're looking at, is how can we preserve a way of life? How do we push these thoughts and processes into our laws? For us, we have to understand what our internal laws happen to be. If we can understand that, if we can get our courts, tribal courts, to understand it, and we can push it into our decision processes, when it goes up into the federal courts, suddenly you have a tribal court interpretation of the Declaration of Rights of Indigenous Peoples that explains what our rights and comprehensions happen to be, and perhaps you get into federal law. Perhaps you find a source and foundation of how these things might occur. Now, George Whitman passed away a couple weeks ago. He was one of our tribal members. 3 tours of Vietnam. He grew up with his grandma Polly, Golaha Polly Long. My mom, Josephine Bigler, grew up with her Golaha Millie Bighead. I had not heard that about George, but when he was young, in the 50s, when the BIA superintendents would come around to gather up the kids to send them off to boarding schools, Polly would throw those 3 boys up onto the rooftop and tell them to go on backside so that they wouldn't see him, they wouldn't get shipped off to boarding school. So when they did that, of course, he stayed at home, grew up with Polly. Polly didn't really speak English, so George grew up speaking Yuchi. My mom, in the 1920s, was raised by her grandma. She let the kids go to boarding school. My mom was the oldest of 5 children. When they came back home, one day they were playing out in the yard, and I apologize for how I pronounced it, but she heard them. My mom said, we must have been speaking English out in the yard playing after school. She came out and yelled at us, said, Ditsoliha, Nedze Yujiha, Gaka wait on Neko, Yuji Haligo wait in a wake. He said, you are Yuchi. This is my house. You're going to speak Yuchi when you're here. She didn't care what happened to them in boarding school or the white man's school. They were going to speak Yuchi. Now, Yuchi is a language isolate. That means that it's not related to any other language in the world. My friend Mary Lynn, a linguistics professor, now at the Smithsonian, said that you've got to go back 6,000 to 8,000 years ago to find a potential relationship for our language to another language. That means we as Yuchis have been who we are for 6,000 years, 8,000 years. She said what that means is that your language and you as Yuchis have been who you are for longer than the European Hindu language family has been one. So back in the time when Hindi, Celtic, Sanskrit, Turkish, Slavic, Greek languages were one language, Yuchis were who we were before the pyramids. We've come down this far because of our language and our culture, and because we had stubborn old women who would throw their kids up on top of the roof. The question is, what are we as Indians going to do for the next 60 years, 100 years, 1,000 years to see that we continue on? This document may be one way in which we can do it. It's not perfect, but the question is, does it help us to understand where we have our own system of thought, laws, jurisprudence, that we can then push into federal law? We have to push that up into federal law, even as our friends are pushing it down for the United Nations. Thank you.
Great, and thank you so much for that very thought-provoking set of observations, Judge Bigler. I'm struck by the observations on the previous panel about self-determination and sort of elucidating more on that through this group of speakers. Our next speaker will be Carla Frederick. Carla is the director of the American Indian Law Clinic here at the University of Colorado Law School, and she is also the director of the First Peoples Investment Engagement Program, a program with the University of Colorado Leeds School of Business, and she is a very proud member of the Hidatsa, Mandan, and Arikara tribes. I said Hidatsa first. I don't know if you... Yeah, I mean, because we're Crow and, you know... There you go. So Hidatsa comes first in my book. Anyhow, Carla's going to kind of continue on with the theme that Judge Bigler started with and talk a little bit more about how we internalize the provisions of the UNDRIP as provisions of tribal law through our own worldviews, and how diverse that approach can be between different tribal nations, even here just within the United States.
Thank you, Heather. Thanks, everyone, and thanks to Kristin Carpenter for putting together this amazing conference. For those of you following your program closely, I am not Tim Coulter. I am here filling his enormous shoes. He was unable to make it here due to the storm. He's still in Montana. But I approach this talk in the spirit of many conversations I've had with him about this very issue. So when I was asked to fill in today, I was thinking about the question of self-determination and implementation of the Declaration, which is something I've been thinking about for some time, really coming out of work that we did with the Spokane Tribe of Indians and the Standing Rock Sioux Tribe. Two very distinct engagements with two very distinct set of issues, but I think that they're very instructive to think about how tribes are approaching implementing the Declaration on their own, while also recognizing that it is not their obligation to themselves implement. So it's kind of an interesting paradigm there, but I think that it's best summarized by the famous title, Why We Can't Wait. I don't think that tribes want to wait and see what's going to happen in the courts or in U.S. policy, and the issues that we're facing right now in Indian country are producing some dire impacts on our people. And that's, as we face these issues, as we face these impacts, as we consider how to move forward and look ahead to the next generations, tribal leadership is really engaging with some of the concepts in the Declaration quite vociferously. So, as Heather said, I run the American Indian Law Clinic. It's been my privilege and honor to do that for the past several years. One of the earliest clients that we took in the clinic in my tenure was the Spokane Tribe of Indians. And they came to us really asking about how they might engage with free, prior, and informed consent. The way that they had come to think about free, prior, and informed consent was actually really interesting and has really informed how we are thinking about this as a program, especially with the First Peoples Investment Engagement Program. The way that they first heard free, prior, and informed consent invoked was when Newmont Mining came to them and said that they had been through a free, prior, and informed consent process with the tribe already, and had made decisions about how they were going to handle their obligations on the Superfund site that was on the Spokane Reservation. And the Spokane tribal leadership was very surprised by this because they didn't feel that they'd been through any type of process that looked like consent. They had been through multiple consultative processes throughout dealing with this open pit uranium mine that's sitting just adjacent to their reservation, which is a theme that will continue in the next thing I'm going to talk about. But they did not feel that they had been that they had given their consent to the behavior of the company and to the process that was then envisioned. I should interrupt myself for a second and say I was looking for my faculty colleagues out here, and I remember that I'm missing a faculty meeting to do this. So if you see me looking even more delighted as I go on, that's what happened. Okay, so Spokane came to us and they said, help us think about what FPIC would mean on the Spokane Nation. And they were also in the process of thinking about how they would re-envision their tribal leadership and move out of a way that really wasn't working for them and into a new era of tribal governance. And this is also kind of a recurring theme that we've been seeing. Of course, all of you know about the Indian Reorganization Act in this room. I'm not going to bore you with the details of all of that, but I think it's suffice to say that many tribes now find themselves in a governance structure that they didn't necessarily choose or construct. And so thinking about how to return back to more traditional forms of governance seems to be in many situations intersecting with how they're thinking about new paradigms of international Indigenous rights law and how that pertains to them and how it might inform some of their processes. So what we did for Spokane was twofold. We thought about how to operationalize free, prior, and informed consent on the reservation as to outsiders, as to folks who wanted to engage with the tribe who were not themselves tribal citizens, entities like Newmont Mining, who themselves have already articulated, as many in the mining and extractive industry have, due to incredibly high asset risk that gets created by social opposition to projects. They have already articulated free, prior, and informed consent protocols, which is what Spokane was facing when they came to us. But how could Spokane articulate free, prior, and informed consent to the outside that would also, and this is really key, would also have remedial measures attached to it, so that if those articulations were not respected, that Spokane would have remedy. And that's really critical, because we've talked a lot about consultation, we've talked about FPIC, but the thing that's very unsatisfying in this space is that if any of that goes wrong, there isn't really a clear path to remedy. And so one of the thoughts that we had, borrowing a page from something that was going on sua sponte on my reservation, which was a response to some of the behavior of the oil and gas companies that are doing business up there, is that every time the oil and gas company would do something the tribe did not agree with, the tribe would revoke their business license. And I was like, well, that's kind of interesting, because once you don't have a business license, and you can't drive a semi, theoretically, through the reservation. And you can't haul frack water through a reservation if somebody caught you dumping on someone's allotment, and they got wind of it and yanked your business license. And so we started looking into, well, what are the possibilities, understanding that there are civil jurisdiction frameworks under the Montana cases, what are the possibilities for employing some sort of remedial mechanism to create a free, prior, and informed consent framework for the Spokane tribe? And so we tied the free, prior, and informed consent protocol to the business licensing provision and to the TRO for the tribe. And the tribe hasn't yet implemented this because they're a little worried about setting a litigation fire that Matthew Fletcher will write an amicus brief for. But there are some unsettled questions of law, but that's how we set out to do it. And then they also, as part of the leadership and decision-making process that they wanted to engage in, did something that was very unique, which is, we talked this morning about tribal sovereignty and how tribal sovereignty has become this really dogmatic thing, and yet there's many different ideas about how tribal sovereignty, what it means and how it should look and how tribes should make decisions. Spokane really wanted to get back to a form of more community-based decision-making, and so they themselves committed to engaging in free, prior, and informed consent with their own membership, which was really interesting. A little controversial with some people because tribal sovereignty, as I said, is a very importantly held right and value, and for the tribal government to take that step to I guess, waive their own sovereignty in some respects was a little troubling to some. But I think it was important for them to really self-articulate that. So I'm running out of time. I just want to mention Standing Rock because we worked with the tribe in Standing Rock in a couple of significant ways where their own self-determination and their own articulation of the principles of Indigenous rights as reflected in the Declaration came forth. Standing Rock was really the first time that people in the community started talking about FPIC. And that was very powerful. We all witnessed that. So I think messaging for a movement around FPIC was something that was very powerful coming out of that. We worked with the tribe on both their international advocacy strategy and their advocacy strategy with banks who had interest in the pipeline and then the pipeline company itself. And in both of those engagements, of course, the declaration was invoked as setting forth or rather reflecting the appropriate rights-based framework for the tribe. Some of you in this room know this already, but there were some suggestions about the possibility of invoking the UN Declaration in the litigation itself in the United States, and those were ultimately rejected by the tribe. I bring that up only to say that, and I think that Matt also mentioned this morning, when you're in high-stakes litigation with a client, really tough to do something that looks like legal reform. Because as an attorney, your obligation is to your client is to win your case, and there's not really a lot of wiggle room to create a distraction for the court. One thing I will say about invoking these international processes and international frameworks in that case is that we definitely noticed there's some serious resource and capacity issues. Educating the tribes about the instruments is really, really important work and has to be done. Anything we do in this room, I don't think is worth very much if we don't do that, because if they don't know how to invoke these rights themselves, then forget it. The lack of remedy, as I said before, very frustrating. We filed a case invoking the American Declaration, the UN Declaration, a bunch of other instruments, which was really a preliminary injunction request before the Inter-American Commission on Human Rights. It's 2019, that was 2016. They still haven't done anything about it. So, you know, it's not a silver bullet, but I do think that that engagement really amplified our messaging and amplified the cause and amplified the corporate engagement and created the type of activity that the tribe really wanted to engage in to disrupt the pipeline. So all of these things are very interconnected, which is something I wanted to point out. One last thing I will say is that one thing that we increasingly see in the corporate context, which is very frightening, is that there seems to be, and why this conference is so important, there seems to be indicia from extractive industries in particular, and others who want to develop and have impacts on Indigenous peoples without engaging with international law, that it is sufficient to rely on domestic law in order to satisfy their obligations on human rights for a project, and for all sorts of reasons that's not right, but it's also really demonstrative of how important it is to reform the domestic framework, because those two things will always interplay, and it's a very easy out for a company to say, well, Corps of Engineers granted us the permit, and that's the law of the land. So thank you all for your time, and I just want to say to Judge Bigler, I really wish Bill was here. So.
Thank you, Carla. Our next speaker will be Winona Single. Winona currently serves Michigan Governor Gretchen Whitmer as Deputy Legal Counsel, and she has been in that post since January of 2019, so very exciting development in Winona's life recently. She also serves as the advisor to the governor on tribal affairs, where she works to strengthen the government-to-government relationship between the state and Michigan's 12 federally recognized tribes. Prior to that appointment, she worked as an associate professor at Michigan State University College of Law, where she taught federal Indian law, property, natural resource law, and 2 advanced Indian law courses, and served as the associate director of the Indigenous Law and Policy Center. She also simultaneously served as of counsel for Kanji and Katzen PLLC, a firm with offices in Seattle and Ann Arbor, representing Indian nations across the country. She has served as Chief Appellate Justice for her own tribe, the Little Traverse Bay Band of Odawa Indians, and as the Chief Appellate Judge for the Grand Traverse Band of Ottawa and Chippewa Indians. She was previously a member of the Little Traverse Bay Band's Economic Development Commission. President Obama appointed her, and the Senate confirmed, as a board member of the St. Lawrence Seaway Development Corporation. Without further ado, here's Winona to talk a little bit about some of the unique developments in her part of the world.
Honored to be here, and I want to thank Kristin Carpenter and Ed Yall for all the preparations and hard work that went into bringing everyone together today. So thank you, miigwech. My comments today are focused on self-determination and the role of state governments in respecting Indigenous rights to self-determination. And as the first Anishinaabe Kwe to serve in the position as the governor's advisor on Indian affairs, I thought that I would also think about this from the perspective of Minobamadzwin, which is the Anishinaabe-Moan word for living the good life. So first of all, I find that there are 3 different ways in which state governments have the capacity to respect Indigenous rights to self-determination, or 3 categories that I've divided this universe into. So one, I see as recognition, which I also see as respecting the 7 grandfather teachings of truth, Debwewin, and respect, Minaden Dimawin. And the second I see as consultation, which also involves the values of respect, Minaden Dimawin, as well as honesty, which is Kwekwa Zwin. And in addition, humility, which is Debaden Zwin. What is the difference, you may ask, between truth and honesty? Truth being relevant to recognition, and honesty being important in my mind to consultation. Well, one, honesty represents not only speaking the truth, but also living one's life and acting in a way that has integrity, that is consistent with that truth and with one's own personal knowledge. And I think that consultation also involves a government-to-government relationship in which a government gives actions to its words and implements processes which are consistent with its verbal commitment to recognize Indigenous sovereignty and self-determination. The third area that I create, the third category that I recognize is collaboration. So I see 3 areas: recognition, consultation, and collaboration. And with regard to collaboration, I also see the Anishinaabe values of bravery, respect, and potentially love. So with this, I want to begin by thinking about recognition. One thing that we have and that we've inherited in Michigan from prior administrations is a series of executive directives that were promulgated using the authority of the office of the governor, as well as a series of accords. And those accords are government-to-government agreements between the state of Michigan and Michigan's 12 federally recognized tribes. So each of those executive directives and those accords, of course, recognize the inherent sovereignty of tribal nations. They recognize that tribal nations have long preceded the existence of the state of Michigan, and that tribal nations have the right of self-governance and self-determination. They recognize the variety and diversity of tribal governments in the state of Michigan, and they recognize tribes as exercising jurisdiction over their lands, resources, and communities. Each of these executive directives and accords recognizes also that the state is obligated by federal law to respect Indigenous treaty rights and other sovereignty and other rights. So this, of course, is a start. But it's not, of course, the end either. The state has long had a history of conflicts with tribal governments, and there are potentially future conflicts as well. But this is an important beginning and an important foundation to build upon. One thing that I also find to be important with regard to recognition and truth, to Lewin, is the notion that in addition to the state recognizing tribes as sovereigns and recognizing tribes as having this power of self-governance to independently govern their own communities, one thing that I find to be lacking within the state of Michigan's various departments and even the executive office of the governor is a deeper recognition of the experience of Native peoples in Michigan. A deeper recognition of history and how it's impacted Michigan tribes, of colonization and how it's impacted Michigan tribes. And so just some examples of that, for example, I begin with, in my own family, the fact that we have a history of many generations of families being separated and torn apart against their will. If we begin as early as the period of statehood in the state of Michigan, one thing that is certainly not recognized in Michigan general history books or in the Michigan public school curriculum, and not a form of knowledge or information that many in state government are aware of, is that we have a history of forcible removal that was part of the dispossession of Native people. That we have a history in the 1830s and in 1840, in particular with regard to a general of the US military, Hugh Brady, who was charged with forcibly rounding up and assembling Native people, Anishinaabe, from the lower peninsula of Michigan to remove them west. And that there are stories of settlers in the pioneer and settler historical accounts of the Michigan Historical Society that document and that reflect this history of seeing tribal members fleeing to escape the military led by General Hugh Brady, and of forced encampments of tribal members who were in fact rounded up and forcibly detained while they awaited their forced removal. There are even longer documents that contemporaneously describe the personal life stories of individuals who were impacted by this forcible removal. And these stories are not widely known at all. They are not recognized in Michigan history. We have other eras of dispossession in Michigan which are not recognized. There is very little understanding or recognition of the concept of an allotment and how they were promised to Michigan tribes in exchange for their reservations, yet how the promise was not fulfilled. We have very little, if any, recognition throughout the state of Michigan of what happened at the community of Burt Lake, where my ancestors lived in Michigan. In Burt Lake, the tribal community purchased land in fee simple, sold that land to the governor of the state of Michigan, and in the year 1900, in October, the sheriff of Sheboygan County and John McGinn, a lumber investor, burnt that village down to the ground on the false belief that the land had been properly sold in a tax foreclosure and was no longer owned by the tribes. We have very little, if any, recognition throughout the state of Michigan of the history of Indian boarding schools and of the many generations of Native children from Michigan who attended these boarding schools so that they would be forcibly assimilated, separated from their families, not able to learn their culture or language, and taught menial skills. And we have very few in the state who recognize the state's history of removal of Native children and placement of those children in foster care and adoptions, a history which is well documented by passage in the testimony before congressional hearings before the passage of ICWA in 1978, but a history which had continued long after that. So in my own family, I have ancestors who've been impacted by every period of this development, from family members separated by adoption and foster care, to grandparents that attended Indian boarding schools, to those who lived at Burt Lake, and to those who fled southern Michigan to be able to avoid forcible removal in the state at that time period. And I think that a true recognition of the truth of Michigan's tribal communities would include respect for that history, as well as respect for the traditions and cultural values of tribal communities as well. There are very few in Michigan who even know what Anishinaabe refers to, that it is the language of Michigan's tribal members. And there are few who realize at this point in our history, when we recognize the significance of the Great Lakes, which provide 20% of the world's fresh water, that Michigan's Native people, in their traditional ceremonies, spend a significant portion of their ceremonies and spiritual energies focusing on celebrating and honoring and respecting fresh water. So I think that we do continue to need to have a much deeper delving into recognition and truth. With regard to consultation, we have a history of executive directives and accords, which require that departments appoint tribal liaisons that will work with tribal governments, that will require a process of consultation, including timely notification of actions, policies, rules, and laws that may impact tribal interests. And that there's also a process recognized in these accords in which a tribe can elect to initiate a consultation with a state department. These are important strides forward, but they don't exist uniformly across the departments, and there is no uniform or coordinated approach with regard to recognizing tribal interests in lands and cultural resources. And furthermore, of course, there are many examples of consultation that has been unsuccessful in recent Michigan history as well. We have, for example, the instance of Eagle Rock near Keweenaw Indian community's traditional territory, where the state recognized that state law required that a place of spiritual significance such as Eagle Rock, that it needed, that before a mining permit could be granted for mining activities at that sacred site, it was recognized under state law that it was needed to determine whether the mining activity could have any negative impacts on places of worship. And where a Michigan state court interpreted that a place of worship is limited to a place with walls and a ceiling. So we have these examples, and which demonstrate that while a consultation policy may have existed for the past 17 years in Michigan's history, we still have a long ways to go to strengthen that process and to ensure that there is a deeper recognition of when it's required, when it's triggered, and who must be involved in the consultation process, and what kind of information should be collected. Then we also have the third category, which I identified, which is collaboration. I don't have more time to speak, but I do want to acknowledge that there are some important strides being made in this area, and that those and one thing that they demonstrate is that the history of accords and executive directives, while they may not have been implemented perfectly, they did create an annual process of tribal state meetings and partnerships over water, climate, energy, and economic development, and that because of those regular meetings and partnerships, initiatives have grown out of them in which there is true sharing and collaboration. So one of those is the Michigan Wild Rice Initiative, in which several state departments, federal agencies, and all of Michigan's 12 tribes are partnering together to support the restoration and conservation of monoman wild rice in Michigan. So, miigwech.
Thank you, Winona. And as time goes on, maybe we can put you and other Michigan folks in touch with some other states and help them forge that same path. Our next and final speaker is Angela Riley. Angela is a professor of law at UCLA, teaching federal Indian law, cultural property, and property law, among other topics. She received an undergraduate degree from the University of Oklahoma and her Juris Doctorate from Harvard Law School. After law school, she clerked for Chief Judge T. Kern of the Northern District of Oklahoma, and then worked at the law firm Quinn Emanuel, where she practiced intellectual property litigation. She is a citizen of the Citizen Potawatomi Nation, and in 2003, she was appointed to serve on her tribe's Supreme Court, which made her the first woman and the youngest ever justice. She was elected in 2010 and 2016 by her tribe's general council to serve as the Chief Justice. In addition, she is an evidentiary hearing officer for the Morongo Band of Mission Indians. She is also the co-chair for the UN Indigenous Peoples Partnership Board, which works on implementing the UN Declaration on the Rights of Indigenous Peoples. She writes primarily around cultural property and Native governance and has been published in a wide variety of journals, including the Yale Law Journal, Columbia Law Review, California Law Review, and Georgetown Law Journal. She authored an Indian Law Casebook, American Indian Law, Native Nations, and the Federal System, alongside Robert Clinton, Carol Goldberg, and Rebecca Sosi. Come on up, Angela. Thank you.
Yes. Just getting my PowerPoint up here. Great, thank you. Good afternoon, everyone. I wanted to just start by acknowledging the Indigenous and traditional owners of this land, the Cheyenne, Arapaho, and the Ute peoples. I wanted to start by thanking everyone who's been a part of putting this together. It's been a really remarkable day. I know we have reflections after this, but since this is the last panel, I sort of felt like it was a moment to kind of exhale and look around and just be incredibly grateful that we can be in this room together and convene around these ideas and inspiration that we've gotten here today. Like many people in this room, I've been thinking about self-determination and Indigenous peoples' rights and vision for the future for a long time. And I have to just mention, I've been so inspired by the work of many of the people here. And of course, can't name everyone, but I just have to point out some of my own mentors, teachers. I took Indigenous Peoples in International Law from Jim Anaya when it wasn't even a book yet. It was just a bunch of loose leaf papers. Rob Williams, Rebecca Sosi, Charles Wilkinson, John Echohawk, the list goes on, have done enormous work in many, many areas of Indigenous rights, including cultural and political sovereignty, and Rebecca Sosi's really been the leader in that, that I've relied on in my own work. I thank the organizers, of course, of the conference, Jael, and Kristin Carpenter seems to make everything possible and made it back from the faculty meeting too. So thank you, Kristin. So to turn to the question at hand, I was asked to talk about what does self-determination look like in the future. So you can see up here, the name of my talk is Self-Determination and Sustainability. This is a talk based on an article called Privatizing the Reservation, ? That should be out in the next few months. It is co-authored with Kristin Carpenter. Luckily for you, you get to listen to the 10-minute version instead of read the 90-page version, so congratulations. So let me just talk a little bit about what do I want to focus on today. In the article, Privatizing the Reservation, we're focused in that article on a more kind of a smaller set of problems, looking particularly at economic development on trust lands in Indian country and the issues and problems arising from housing. So I'm going to kind of pull back from that a little bit and use some examples later in the talk, but really mostly kind of give more big picture ideas of what inspired us. I want to acknowledge the Native Nations Institute because we used a lot of their work in terms of data and data analysis from the last census to sort of track economic development and housing issues in Indian country. One of the things that really inspired us to write that piece was to really push back against what we call a privatization rhetoric in the United States. Essentially, our paper argues that if you look within the United States and beyond, there's a model of Indigenous self-determination and a corresponding ethic of sustainability that's emerging as an alternative to a privatization model and wealth maximization rhetoric that swirls around Indian policy today. And this model is not our invention, but it's what we've observed in Indian country and in Indigenous communities around the globe. All of you, of course, are aware of the economic struggles that we have in Indian country, even though gaming has made a big difference for some tribes. There's still many, many issues around poverty and much need in Indian country. And because of this poverty, there's a group of economists, and if you want to read about them, I'll refer you to the paper, but a group of economists who have promoted really the free market and privatization as a way to really address Indian poverty on reservations. The idea essentially is that things like collective ownership and trust lands impede the free market, and that because Indians don't have the same private property that non-Indians do, this is what is making us poor. This argument has a lot of nuances, but that's really kind of its core claim. It bears noting that we see similar developments around the world, in Brazil, in the Amazon basin, elsewhere in South America, across Southeast Asia, and many others. Hundreds of years of experience with colonization as Indigenous peoples, and now not hundreds of years, but decades as scholars, have given us a healthy degree of skepticism that privatization is not really promoted to help Indigenous peoples, but as Rob Williams pointed out in his talk, to open up more of the world's valuable and scarce resources, from water to timber to land and others, to extractive industry to benefit non-Indigenous peoples. So what's happening in the US? I'll just give a few examples from the last couple of years. This particular administration has had a focus on privatization in a variety of ways, including breaking up collective land or land that would be set aside either for conservation by the federal government or for tribes. Bears Ears, of course, comes to mind, which was discussed at our lunch today. The Bears Ears area, of course, is rich in natural resources, and the New York Times did a story not long after the decision to shrink Bears Ears that there were emails evidencing that there was discussion about the enormous riches, including oil, in that area, and it served as a motivation for shrinking Bears Ears. Tribes all across the United States control lands that are rich in natural resources that extractive industry would like to access, and with less regulatory oversight. We've seen some people in the Trump administration question the trust status of land, and of course we have the issue with the Wampanoag, which the threat to actually remove their land from trust, which would be the first time I think that's happened since the termination era. These are what we call the push for privatization of lands and resources. So our work asserts that Indigenous peoples' rights, my clicker here, that Indigenous peoples' rights to their land and resources and what they intend to do with their lands and resources must be acknowledged and respected. And this has led us to look at a thick conception of self-determination as embodied in the best of US law, and it's also heavily informed by international norms, particularly the UN Declaration on the Rights of Indigenous Peoples. And this is our emphasis on self-determination. At the same time, we firmly situated Indigenous rights in our own work in a theory of environmental sustainability. We do so because our personal experience engaging with tribal communities, and as you saw earlier in panels with Kristin and Greg and Steve talking about the connection of Indigenous peoples to the earth, a connection I do not need to explain to this audience, Indigenous peoples around the world convince us of the necessary and symbiotic relationship between Indigenous peoples and our mother. But it does not end there. We wrote this paper in part with the idea that given what we feel humans are doing to the planet, and much of it being done blatantly out of a thirst for power and greed, we believe all humans have a moral imperative to move towards sustainable living on this planet. And we look to the UN sustainability goals to inform our thinking in this area. And of course, doing this work is much easier than it sounds because we didn't invent or create any of this. We learned it from other people and we observed it in Indigenous communities. So what I'd like to do now is just turn to 3 examples of Indian tribes in the US whose policies already exemplify these principles in action. So the first one I want to talk about is the Ho-Chunk tribe in Nebraska. This is just a snapshot. These tribes their stories are incredibly rich, their histories are incredibly multifaceted. Many of them were removed from Aboriginal territories to new territories. Some of them had allotted reservations. So their experiences are really, really very rich. So I don't mean to just, condense them down to a slide with bullet points, but I did want to just point out a few of the things that we saw as interesting, especially around the use of property and self-determination in Indian country. I guess one of the things I want to just mention is that in the examples, and and there are more in the paper, we really wanted to defeat the idea of an on-off binary of private property or collective property, as if there's nothing in the middle. There are all kinds of innovations that tribes are coming up with to satisfy the contemporary needs of modern tribal members, many of whom also want to own homes and do other things, but also invigorate and revitalize an Indigenous community for a collective life. So we tried to find examples of places we thought some of this was happening. One of the examples we used was from the Ho-Chunk Nation. One of the issues that was identified was that there was inadequate housing on the reservation. So there were people who were leaving the reservation to find work, and therefore they would stay away and they would find work and housing. There were people who, at times the housing was so tied to income levels that people who were moving up in socioeconomic class were no longer qualified for housing on the reservation and had to move off the reservation. The quote from Lance Morgan, the CEO and president of Ho-Chunk Inc., this is a quote from him. He said, "A majority of the housing is owned by the tribal government and has income restrictions, which ironically forced our emerging middle class to leave our community to find housing. The very people who should be natural community leaders were moving to communities where housing was readily available and not participating fully in our growing economy." So some of the workarounds that they created Ho-Chunk Village, which is a multi-use project located within the reservation where you can live, oh, sorry, I think I'm supposed to keep this on, where you can live and work and engage in your community life. The project, interestingly, is located on 40 acres of fee land within the reservation, which they set up for that purpose with fewer restrictions. They're also promoting asset building through home ownership, and they've moved into clean energy development. And I have a couple of other things that they're doing up here. The next slide, I have to give a full disclosure. It's my own tribe. So if this is being streamed anywhere in Potawatomi County, Chairman Barrett, you're my hero. This is the Citizen Potawatomi Nation in Oklahoma. You can see that I have here removed. When you wonder how could there be Potawatomi so far north and all the way in Oklahoma? Well, we were the ones that just kept going. So my tribe ended up in Oklahoma. We started out a couple of decades ago with a few acres of trust land, $500 in the bank, and a trailer house as our tribal headquarters. We now have an enormously flourishing tribal community. We have a bank, we have all kinds of housing, a casino, restaurants, a golf course, et cetera. And one of the issues that our tribe has really done is to reinvest money in our tribal community. And I think one really unique feature of this that I personally found to be really powerful, some of our ceremonies traditionally would involve an eagle feather, but as many of you know, it's very difficult to get them, and especially to get them in enough numbers to do ceremonies in your communities. And one of the things that my tribe did was create our own eagle aviary, where we take in eagles from the wild that are harmed, that can no longer live in the wild, and we have experts there who take care of them, and then as they naturally molt, we use their eagle feathers for our ceremonies to create, our own workaround to revitalize our culture. I'm out of time, so I'm going to skip the next slide and just go to the end. I just wanted to show you this. This is a picture of where I grew up in Oklahoma. This is the 160 acres where I was raised. As you look due north, and yes, Kristin, it's north. As you look due north, that's the 160 acre farm where I was raised. To the east of me is a wheat field that we worked when I was growing up. To the south of me is Saddle Mountain, and to the west of me is Longhorn Mountain. And this word, Jaganaganon, means all my relations. Miigwech.
I want to thank again our wonderful set of panelists here, and also thanks to you, Law, for putting this all together and coordinating everyone. And big thanks to Carla for stepping in at the last minute when Mr. Coulter wasn't able to join us. I think we have about 2 minutes. If anybody has any questions, we can probably take 1 and possibly 2, depending on how complex they are and whether they're things that we can answer. Yeah, in the back.
It's actually a group that is formed a separate community on fee land with an entirely, they call it an immersive tribal community where their language is spoken all the time and they're conducting ceremonies and living that way. And it's set up as a nonprofit. So we thought it was also another innovative and unique way that a tribal community could set itself up together for collective living.
Any more questions? Great, well, thank you all. Oh, we've got one more in the back, Daly.
Actually, I just wanted to make a quick comment. Thank you, Winona, for addressing some of the terminology that we often pass by swiftly in the UN Declaration of Rights of Indigenous Peoples, and that is all of the different provisions that are focused upon states and their responsibilities in the implementation of rights that have been quoted in paragraph above, with reference in collaboration with. So I just wanted to point out, as I'm sure you know, but for others, if you read through the UN Declaration of Rights of Indigenous Peoples, all the provisions that say in conjunction with, in collaboration with, and also Article 26, Para 2, that references not only our ownership, but our use and control of our lands. All of those invite us into the whole neighborhood of consent. And I just wanted to make that comment on this reference to
Wedge.
Great, thank you everyone for your attention, and we'll have the wrap-up session now. Thank you.
Hi, everyone. We're not taking a full break, but we're just sort of changing over the speakers, so give us a second.
No problem. I know you have faculty.
I think you'll be particularly glad that you did, because we have a special feature with our guests from Japan, and you've already met Kenny Yoshida, but he also has, along with him, the Ainu colleagues from Hokkaido area, I think, who were so determined to get here that they drove all the way from San Francisco. So, and they're not even in the room yet, but I think they deserve the biggest A for effort, or, you know, award for determination. And I'm just thrilled that they're here. And so I will turn the mic over to Professor Yoshida, and we'll go from there. Thank you.
Okay, hi again. Thank you for your patience. Since this panel focusing on Ainu issues, named the reflection. So at the beginning, right now, the Ms. Ryoko Tahara is changing her clothes to indigenous clothes, and I'm at the beginning before she comes. I'll ask you some questions, listening to series of panels. First question is kind of a pragmatic one. at the Kristin's class, we've read a lot of cases about the regional implementation in terms of international human rights law. That is inter-American system and African system. But as I mentioned in my presentation, regional implementation system is missing in East Asia and Southeast Asia. That's part of the reason why the Japanese government is still taking a self-complacent, ludicrous indigenous policy with regard to Ainu people. So I'm just wondering if there's any way to broaden these regional implementation systems upon the international pressure spearheaded by the United Nations or expert mechanism. And the second and third question is kind of theoretical question. The first, from the government side, they argue as follows. The Japanese citizen should be protected equal in accordance with the Japanese Constitution, Article 13 or Article 14. 14 is kind of Amendment 14 here in this country. And Ainu people could not get special protection. That's why by rejecting reparations, and they just support the culture that is specific in Japan, that non-political, non-legal cultural protection has been awarded by the Ainu Symbolic Park that is going to be built by 2020. Such argument is persuasive. They said that's the consequence of individualistic liberalism. Are you persuaded? I'm not. Even if you take the liberalism, the individual liberalism, this is the tort issues. So they suffered successive past injustice. In that case, even if you take individualistic liberalism, they should get reward. They should get remedies, don't you think? And the second, all of them, as many indigenous people across the world, the Ainu people themselves take the collective notion of property or collective right as is advocated by UNDRIP. And as the basis of UNDRIP collective notion, there are many cases of inter-American system. For example, our Timmins case in 2001, due to the effort of Dean Anaya when he was in Iowa, as the interpretation of American Convention of Human Rights property articles, he developed empirically the evolutionary, what is called evolutionary interpretation of property notion, as all of you might know. And that collective notion property or collective right notion has been established. That might be the basis of UNDRIP, if I understand correctly. And that collective notion seems very powerful, I think. For example, Professor Wilkinson mentioned Bolt decision. That's kind of the collective notion, collective right of fishing right to overcome the 14th Amendment. And we also have read the Adia case that's about that regarding the Klamath River Basin case. And that decision also supports the collective notion of non-consumptive water right. That is very powerful in this environmental era. And I'm not sure the Amy Cordalis is here, but she'll be around tomorrow at the environmental session. She's right now, her case is in the Ninth Circuit, and I hope she might follow suit to the Adia case. And so these are three pragmatic and theoretical questions to you. So just think about them before our wonderful guest from Hokkaido finally come here. So I look for them. There's any response to my couple questions? Or, okay, please.
Yeah, we had a very vibrant affirmative action program that was meant to address past discrimination of women and color, and that was thrown out by the U.S. Supreme Court in the Bhakti line of cases,
Yeah.
where they ruled that the one individual or two individuals' rights to equal protection was
Yeah.
trump that of the collective rights. So
Yeah. We have to overcome the reverse discrimination discourse.
And then if you look at the Mavo 1 case,
Yeah.
I think it was 1989.
90.
Not the one on the document of discovery, but the one prior to that. They compared the individual right of property to the collective right of property of Indigenous people in northern Australia, and held that the collective right under the International Human Rights Treaty that had been implemented by the state of Australia trumped the individual property rights of the commercial land and developer in Australia. So that's an example where you could have a
Thank you.
collective right of property or collective right of equal protection trumping a individual right.
Any other response? Yeah, please.
I just immediately questioned what date Japan's constitution was amended that allowed for an equal protection clause. Was it after the post-World War II era, or was it later?
That was not amended, the original, here 14th, Article 14.
I know that it sounds like a strange question, but the timing of when that equal protection clause was part of your constitution could have implications for the rights and remedies that your Indigenous people have been harmed. You know, because you mentioned the Klamath Basin case, the basis of Indigenous people's rights to fish go back to the treaty rights.
Yeah.
So we could try to overcome
Yeah, you're right. And as a as a civil scholar, the communal notion of property is well established in the civil scholarship. Yeah, please come. Please. And but the Japanese government, as well as hired constitutional scholar of Hokkaido University, argue that the only individual notion can be accepted. So rejecting, when they signed the UNDRIP in 2007 by rejecting the collective notion of property. Correct? Yeah, please. あ、田原さん、いらしてください。みんな待ってるんです。And as already all of you know, they come to this meeting by driving all night from San Francisco. Let's applaud them for her efforts. And Ryoko Tahara is a very important one of Ainu leaders, women's leaders. She's a president of the Ainu Women's Association and vice president of Sapporo Ainu Association. And in my presentation, I try to give you the overview of the Ainu tragic history. So her general address overlaps with my presentation, so you can understand easily with Professor Jeff Gaiman's translation. And Jeff and I are outside of the ludicrous decision-making of Hokkaido University, but we have alliance to promote the grassroots movement. So please. And some of the mic is on for Jeff's translation. It's on. Okay.
Michael. ではよろしいですか。
この2日間のいきさつとかあった。
はい。イランから来て田原涼子と申します。よろしくお願いいたします。
My name is Tahara Ryoko. I give you my greetings in the Ainu language. It's very nice to meet you all.
はい。今回吉田先生のご尽力によりここでお話しさせていただく機会を得たんですけれども、こちらの当地の吹雪のアクシデントでですね、私たちは昨日サンフランシスコから24時間かけてレンタカーで彼と運転して3時にここにやっと着きました。
So, Professor Kunihiko Yoshida gave us this wonderful opportunity to come and speak in front of everyone. Unfortunately, the blizzards tried to prevent us, but it didn't. We drove all the way from San Francisco, 23 hours, and arrived here just 2 hours ago.
はい。おかげさまで、本当に大冒険をできました。アメリカを横断する、経験を、させていただきました。感謝しております。
And I'm actually appreciative of this chance to have the mighty adventure of driving 1/4 of the way across the American continent.
はい。それではですね、短い話ですけれども、日本の先住民族アイヌの過去と現在と未来をどうするかということを少しお話しさせていただきます。
My words are very brief, but as an Ainu person from Japan, I would like to briefly talk about the past, present, and future of our Ainu people.
アイヌ民族は北海道、千島、樺太をアイヌも知り、アイヌが住む大地として古来より自然と一体化した独自の宗教、言語、文化、生活習慣を持ち、狩猟、漁労、採集によって生活をしてきた北方民族であります。
Ainu are a northern people of hunter-gatherer fisherers who have maintained their own unique language, culture, and religion from time immemorial in balance with the natural surroundings of the islands of Hokkaido, the Kuril Archipelago, southern Sakhalin, which are known as Ainu Moshir, the heartland of the Ainu.
しかし、明治維新によって近代的統一国家を一方的に踏み出した日本政府は、先住民族であるアイヌとの間に何の交渉もなく、アイヌモシリ全土を一方的に日本領土に組み入れてしまいました。また、明治8年には、帝政ロシアとの間に、千島、樺太交換条約を締結して、アイヌの安住の地を強制的に捨てさせたのです。
However, during the process of attempting to become a nation state, which Japan embarked upon with the Meiji Restoration, the Japanese state has unilaterally annexed Ainu Moshir into the territory of Japan, creating a colony of the Japanese state with no consultation nor negotiation with the Ainu people. Additionally, in 1875, with the signing of the exchange treaty of Sakhalin and the Kuril Islands with Imperial Russia, Japan forced the Kuril Ainu to relinquish their traditional homelands.
明治政府は移民政策で大量の人が北海道に押し寄せました。開拓民や大企業に与える土地政策を次々と作っては加付していきました。アイヌにはほとんど知らせず与えずでした。食料である酒漁、鹿漁は禁止とされて、多くのアイヌは飢餓で命を落とす者もいたのです。アイヌの生活習慣を禁止して、日本語を強制し、民族の誇りも奪われた私たちの先祖の苦悩はいかばかりだったでしょうか。
As a result of immigration stimulus policies adopted by the Meiji government, vast numbers of people flooded into Hokkaido from the south. At the same time, large numbers of Ainu died of starvation when their main sources of subsistence, harvesting salmon and hunting, were either banned or severely restricted, and huge tracts of land which had originally belonged to the Ainu were granted to settlers and Japanese corporations, while the Ainu themselves largely were given hardly any land at all. If we think about this history of restriction, suppression of the Ainu language and culture, and the fact that the Ainu have been stripped of their pride, we realize that they have had a very hard road to hoe through history.
明治32年には同化政策を目的とした北海道旧土人保護法を制定しました。このような政府の姿勢に反発もできず、無知猛邁の人種にして、その知識、幼稚とのレッテルを貼られたアイヌ、給与地に縛られて居住の自由、農業以外の職業の選択する自由分も奪われました。差別と偏見を基調にした保護・同化政策によって民族の尊厳は踏みにじられました。このような状況を優勝劣敗の原理に基づき、アイヌの自己責任と言わんばかりの認識は日本の恥ずべき歴史であると思っております。
In 1889, the Former Aborigines Protection Act was established with the goal of assimilating the Ainu into the Japanese state. The Ainu, who were branded as a race ignorant and unenlightened of childish intellect, had no way to oppose the state's stance, and were stripped of the option of participating in any other occupation than agriculture, and the liberty to live on any other land than that provided for them by the government. Their dignity as a people under a patrimonial and assimilationist policy which had prejudice and discrimination as its base. It is a shameful history of Japan that the attitude underlying these policies was based on an assumption of Ainu responsibility for their own downfall under the attitudes of survival of the fittest.
昨年は北海道と命名されて150年目の年であるとして、国や北海道、自治体を挙げてのイベントが多種多彩に開催されました。まるでこの間の150年間の愛の悲劇は全くなかったのようなお祭り騒ぎでした。
Last year, 2018, marked the 150th anniversary of the naming of Hokkaido. Events were held throughout the island of Hokkaido and the Japanese nation by the Japanese state, the Hokkaido government, and various municipalities to celebrate the event. It was just as if the tragic history of the Ainu had never happened.
昨年、北海道アイヌ生活実態調査が報告されました。進学率、就業、収入等、一般との格差は未だ歴然としてあります。深刻な結果は、アイヌの人口が10年前は2万6,000人だったものが、今回の調査では1万3,000人と激減してしまったのです。地域のアイヌ協会の会長はこのことに思い当たると言います。先祖代々貧困と差別と抑圧に苦しんできた。今度こそアイヌ民族の復権につながる法律にしたいと長年活動してきたが、政府が検討する新しい法律には生活も教育も支援も全く盛り込んでないと落胆してしまった。もう全く先が見えないと、アイヌを名乗ることをしなくなってしまったのです。
Last year, the Hokkaido government conducted a survey on the actual living conditions of the Ainu. It is clear and evident that there are gaps in education, employment, and income with mainstream members of society. Additionally, one grave phenomenon is that the Ainu population, which 10 years ago had been registered as 26,000, has now drastically been decreased to 13,000. One chairperson of the local Ainu association had this to say about the situation. Our people have suffered generations of poverty, discrimination, and oppression. We have struggled long years to achieve a law which would generally achieve the reparation of the rights of the Ainu people. I was deeply disappointed that the law being considered for passage right now makes no mention of support for Ainu welfare or educational issues. It is almost as if we have no basis to look forward to for a stability and future. And in such a case, who wants to come out as an Ainu person?
政府はアイヌ民族の定義や憲法上の問題、財政問題、何よりも国民に理解が得られないと、この3月にも制定するアイヌ民族に関する新しい法律は、アイヌに対しての過去に行った不正義にも 全く触れず、先住民族の権利も自己決定権もありません。
The Japanese government has cited lack of a definitive legal definition of the Ainu people, insufficient funds, legal technicalities, and, more than anything else, lack of understanding amongst the general populace as excuses to neglect touching upon historical aggressions against the Japanese people, or to grant the Ainu people the right to self-determination in the new Ainu law. Amidst a lack of an explanation of the historical grounds of this law as to why it is necessary, funds and financial projects for regional promotion are being considered, but these will only lead to a complication of the situation for the Ainu people themselves.
この法律がなぜ必要なのかという歴史的な経過を説明がない中、交付金、地域振興資金などを目玉にした法律を作ろうとすることは、新たな問題が今起こっております。
The competition for funds amongst Ainu communities will only lead to more division.
アイヌばかりが利益を受ける。これは同じ国民として逆差別だ。アイヌは独立して国を売る。などなど炎上して、アイヌヘイトが国会議員をはじめ、右系の団体から日々拡大しております。これではますますアイヌは差別され、誇りを持って生きるどころではありません。
Reactionary conservatives, including members of the Japanese Diet themselves, are engaged in feeding the fires of antagonism towards the Ainu people with remarks like, only the Ainu receiving concessions is reverse discrimination. The Ainu plan to abandon Japan and secede to create their own nation. This type of attitude only is serving to delay the actualization of a society in which the pride of the Ainu people is realized.
過去の過ちの補償、賠償、謝罪をするのは国の責任であります。今一度考えて、アイヌ民族が誇りを持って生活をできる社会にしていただきたいと願っております。ありがとうございました。
Guarantees, compensations, and apologies for the state's responsibility for the mistakes of the past are the responsibility of the Japanese state itself. It's time for us to think about these things one more time and to finally realize a society in which the pride of our Ainu people can be actualized.
If I offer some thanks, will you? I wanted to thank our esteemed speaker and leader from the Ainu people. We're really honored to have you here. May I ask the translator to translate? So I wanted to thank you for coming very much. Before you came in, we said that you should win the award for the person who was the most committed to getting here.
遠いところから来てくださってありがとうございます。アイヌの代表が来てくださったことを光栄に思っているんですけれど、お二人が韓国に到着するまでは一番決心をしてここに来られた賞を受賞すべきだっていうことを話し合っていました。
Some people didn't even make it from Arizona.
そのエリゾナ州からすら来れてない人たちもいる中で、
So you win the prize for sure.
なので一等賞です。
But seriously, we're very grateful to you for your presence, for representing the Ainu people, and for educating us about their situation.
でも冗談抜きにあなたの国連の存在、そして私たちにアイヌのことを教えてくださった、ここにいてくださったことを本当に感謝しています。
So thank you for your beautiful presence and powerful words, and we'll look forward to talking with you tonight at dinner as well as tomorrow, hopefully.
とても素敵な入れたち、そしてパワフルなお言葉をありがとうございます。また食事の時におしゃべりすることを楽しみにしています。
And thank you very much to Kenny for making it possible for our guests to be here. So thank you all. And thank you to all of you for making it through the afternoon, our first day of the conference. It's been rich. I'm just going to leave it at rich because what I really want to say is slightly exhausting, but rich and wonderful. And it's now seriously time for refreshment and relaxation. I have been authorized, I think, by John Echohawk and Greg Bigler and Nija and others to extend an opportunity, an invitation to join all of us at the Native American Rights Fund for a reception beginning at 5:30. If you need to know where you're going, the speakers already know, but they've brought in the invitation so we can point you in the right direction. And the speakers also have a 7:30 engagement tonight. For everybody else, we'll look forward to seeing you in the morning right here at 9 o'clock for the special feature on the International Year of Indigenous Languages, and then the workshops in which we'll have a chance to put into practice everything that we've been discussing. Again, thank you all. Have a good night, and I will see you tomorrow.